Let us discuss the circumstances in which court can lift the corporate veil. These circumstances are the exceptions to the notion of separate legal entity. So, there are two circumstances in which court can lift the veil, that is under judicial interpretations and under statutory provisions. These are also called statutory and common law oblique judicial exceptions to the notion of separate legal entity. Firstly, we are going to discuss the judicial interpretations. The first case is in which the court can lift the veil between the members and the company is for determination of the enemy character of the company. A company is not a natural person. As we all know, company is an artificial person in the eyes of law. But the company may assume an enemy character when the persons in control of the company are residents in an enemy country. In such a case, the court can examine the character of person in the real control of the company and declare the company to be an enemy company. We'll discuss this point on the basis of a case law. Leading case on this point is Daimler Company Limited versus Continental Tire and Rubber Company Limited. What happened in this case? In this case, a company was incorporated in England for the purpose of selling the tires manufactured in Germany by a German company. So, the majority shareholders and all the directors were German residents. On declaration of war between England and Germany in 1914, the persons in control of its affairs became, of course, enemy, and accordingly the company was also declared to be an enemy company. So in this case the court disregarded the notion of separate legal entity and company was also considered as an enemy company when the people who were having control over the affair of the company, when they were considered enemies, because there was a war breaking out between both the countries. Because of breaking of war, the countries were considered as enemy country, and as we all know, whenever war breaks out between two countries, there cannot be no legal trade between those two countries. So in this case, when the people who were having control over the affairs of the company, when they were considered enemies, the company was also considered as an enemy company. So the first circumstance when the court can disregard the notion of separate legal entity is to determine the character of the company. Now the second case is for prevention of fraud or improper conduct, where it appears that the company was incorporated for promoting fraud or for some improper conduct. In that case also court can lift the veil between the company and the members and can consider them as same. It is obvious that no company can commit fraud on its own. It is the people behind the company who can commit fraud. So if the notion of legal entity is used for promoting fraud, in that case court will lift the veil and will consider the members and the company not separate. Leading case on this point is Guilford versus Horn. This case we'll discuss in some other point. Now let us discuss the third circumstance in which the court can lift the veil between the company and its members. For protection of revenue, that is for tax evasion, as it is the duty of every earning person to pay taxes. Now company is also an artificial person in the eyes of law, so company also needs to pay taxes in the eyes of law. If anyone attempts to unlawfully avoid the payment of taxation, he is committing an offense. What rule applies to human beings? It also applies to the company. So if the company also tries to evade its tax liability, of course company being an artificial person, it will not try to evade tax liability. It will be the people behind the company who will try to evade the tax liability of the company. So in that case, again the court can disregard the notion of separate legal entity and can consider the company and its members as same. Leading case on this point is regarding Sir Dhinsha Mukherjee. What happened in this petition? In this case, and the assessee formed 4 different companies and transferred his investments to each of these companies in exchange for shares. assessee ने 4 डिफरेंट कंपनीज बना ली और अपनी इन्वेस्टमेंट्स को उन चारों कंपनीज में डिवाइड कर दिया, बदले में शेयर्स ले लिए. नाउ द कंपनीज रिसीव्ड हिज इनकम. अब कंपनीज में ऑटोमेटिकली उसकी इनकम ट्रांसफर हो गई, बट दे हैंडेड बैक द अमाउंट टू हिम एज प्रिटेंडेड लोन. बट बदले में उनको कंपनीज ने क्या दिया? लोन की फॉर्म में पैसा दिया. हिज इनकम वॉज डिवाइडेड इंटू 4 पार्ट्स, रिड्यूसिंग हिज अल्टीमेट टैक्स लाइबिलिटी. सो उसने अपनी इनकम को 4 अलग अलग हिस्सों में डिवाइड कर दिया, जिससे उसकी टैक्स लाइबिलिटी, ओवरऑल टैक्स लाइबिलिटी रिड्यूस हो गई. इट वॉज हेल्ड दैट द कंपनीज डिड नो बिजनेस एंड वर क्रिएटेड बाय द असेसी सिंपली एज अ मीन्स फॉर अवॉइडिंग टैक्स. अब यहाँ पे कोर्ट ने इस केस में कंपनी की एग्जिस्टेंस को नहीं माना, उन चारों कंपनीज को और सर धिंशा मुखर्जी को कंपनीज कोर्ट ने सेम कंसिडर किया. कंपनीज की एग्जिस्टेंस को कोर्ट ने नहीं माना बिकॉज दे वर कंसिडर्ड सेम. कोर्ट took the decision that the companies were created by Sir Dhinsha Mukherjee just as a means to avoid his tax payments, his tax liability. So, next case where the court can disregard the notion of separate legal entity is where the company is just a clock and a sham. It means company just एक bubble है, एक दिखावा है, दिखावे के लिए कंपनी बनाई गई है. असल में कंपनी और उसके मेंबर्स की एग्जिस्टेंस में कोई फ़र्क नहीं है. कंपनी हैज़ बीन क्रिएटेड जस्ट एज अ mere sham or clock. And leading case on this point is Guilford Motor Company versus Horn, as I discussed in the point of prevention of fraud and improper conduct. You can discuss the same case at both the places in both the points. So what was this case? Horn entered into an agreement with his employer company that after the termination of his employment he will not solicit the employer's customers for a certain period of time. जब उसने नौकरी छोड़ी, उसने अपने एम्प्लॉयर को प्रॉमिस किया हॉर्न ने कि वो एम्प्लॉयर के कस्टमर्स को एक पर्टिकुलर टाइम पीरियड तक टारगेट नहीं करेगा. Soon after the termination of his employment, जब उसकी नौकरी छूट गई थोड़ी देर बाद, he formed a company in which 2 shareholders were his wife and one another person. The company sent out circulars to the customers of his former employer. उस कंपनी ने क्या किया? जो उसके फॉर्मर एम्प्लॉयर के कस्टमर्स थे उनको सर्कुलर्स भेजने शुरू कर दिए, उनको टारगेट करना शुरू कर दिया. अब यहाँ पे हॉर्न और उस कंपनी की एग्जिस्टेंस को कोर्ट ने अलग अलग नहीं माना. Court disregarded the notion of separate legal entity and court decided that that company was just created as a bubble. वो कंपनी सिर्फ दिखावे के लिए ही स्टार्ट की गई थी. So court disregarded the existence of that company and court disregarded the notion of separate legal entity. Next point is for Ultravirus Acts. Every company is bound to perform any act within the scope of its memorandum and articles of association. Memorandum and articles are very important documents of the company. We'll discuss about these documents in our next chapters. But here I'll just tell that these are very important documents of the company. So if any act is done which is beyond the scope of memorandum of association of the company, that is called ultra-virus. Ultra-virus means beyond the scope of the company, beyond the scope of memorandum means beyond the scope of company. So any act which is beyond the scope of memorandum is ultra-virus. वो कंपनी के दायरे से भी बाहर आ जाता है. So in case any ultra-virus act is performed by any member or shareholder of the company, the court can disregard the notion of separate legal entity. So here also court will assume the members and the company as same when any ultra-virus act is performed. In that case, the member and the shareholder, the director who performed that ultra-virus act will be personally liable for towards that act. Company will not at all be responsible for that act. Next is for public interest or public policy, where the conduct of the company is in conflict with public interest or public policy, the court is empowered to lift the veil and personally hold such person liable who are guilty of the act. अगर कभी भी कोई भी ऐसा काम कंपनी की तरफ से किया जाता है जो कि आम जनता की भावनाओं को नुकसान पहुंचाता है, इन दैट केस ऑल्सो जिसने भी वो एक्ट कमिट किया है, कोर्ट उसको पर्सनली कंसिडर कर सकती है एंड कैन डिसरिगार्ड द नोशन ऑफ सेपरेट लीगल एंटिटी. Next point is regarding agency companies. Wherever a company is acting as an agent of its shareholders or of another company, the court can disregard the notion of separate legal entity. Leading case on this point was of RG Films Company Limited. What was the case? An English company was formed with a capital of 100 shares in one share each, 90 of which were held by an American. कंपनी के टोटल 100 शेयर थे जिसमें से 90 आर हेल्ड बाय अमेरिकन. द डायरेक्टर ऑफ यूएस फिल्म कंपनी, एन इंग्लिश कंपनी वॉज फॉर्म्ड and issued 900 total shares, out of which 90 were held by an American who was the director of US film company and 10 were held by some another director. Now company produced a film. उस ब्रिटिश कंपनी ने एक फिल्म प्रोड्यूस की. The name of the film was Monsoon. The production was financed by the company. The court refused to agree that the film was produced by British company because the court considered that as majority of the shareholding is in the hands of that US film company's director. So court disregarded the existence of separate companies. Court disregarded the notion of separate legal entity and both the companies were considered as same. Court disregarded that the film was production of British company as company was merely acting as an agent of US film company. कंपनी यूएस फिल्म कंपनी की एजेंट के फॉर्म में ही कोर्ट ने कंसिडर किया एंड कोर्ट डिसरिगार्डेड द नोशन ऑफ सेपरेट लीगल एंटिटी. देन in case of formation of subsidiary company to act as an agent, again the court can disregard the notion of separate legal entity. Every company law distinguishes between holding and subsidiary company. The concept of lifting the veil is a changing concept. It can be lifted for the benefit of the company too. So whenever holding companies under Indian company law are the companies which have a right in composition of board of directors or which have more than 50% of the total share capital of the subsidiary companies. So for example, Tata Sons is holding company, whereas Tata Motors, TCS, Tata Steel, these all are its subsidiary companies. So whenever the subsidiary companies are created just for the purpose of creating a bubble, in that case also court can disregard the existence of subsidiary companies and can consider the holding and the subsidiary as same companies, although they are subsidiary companies of that holding company. Then court can also disregard the notion of separate legal entity if this notion is used for avoiding welfare legislations. So leading case on this point is regarding Workmen of Associated Rubber Company versus Associated Rubber Company. What was the case? A subsidiary was formed to split the profits of the company so that incidence of bonus in the hands of parent company can be reduced. कंपनी ने क्या किया, एक सब्सिडरी कंपनी क्रिएट की अपने प्रॉफिट्स को डिवाइड करने के लिए, ताकि कंपनी का जो बोनस पेमेंट की लायबिलिटी बनती थी अपने एम्प्लॉयज़ के प्रति वो कम हो जाए, उसको अवॉइड करने के लिए बोनस पेमेंट्स को. बट द सुप्रीम कोर्ट के पास जब वर्कमैन ऑफ एसोसिएटेड रबर कंपनी ने केस किया तो वो केस जीत गए. सुप्रीम कोर्ट डिसरिगार्डेड द एग्जिस्टेंस ऑफ सेपरेट सब्सिडरी कंपनी बिकॉज the court considered that subsidiary was created just for the purpose of avoiding the welfare legislations. So here also court disregarded the notion of separate legal entity and both the companies were considered as same. So this was all about the judicial interpretations and the common law exceptions of separate legal entity. In the next video, we'll talk about statutory provisions, and after completion of statutory provisions, we will discuss the whole topic in your online class. But before the online class, I wish all the students to listen to these videos very carefully because this is somehow a technical topic for you people. Thank you.